Well, hello, Uncivil Law friends. I hope you're having a great day, and we are here with some proposals to the amendment to the Communications Decency Act, Section 230. This would qualify as a big deal. Section 230 is pretty much the backbone of the internet as we know it and potentially love it, question mark, as it exists today. And hold on. And so we are here with some proposals to amend this thing, which is the backbone of the internet as it currently exists. And so we are going to try to figure out, is it a good idea or is it not a good idea? So first, let me explain what Communications Decency Act Section 230 does. It's actually fairly simple in its application. So first you have to know how defamation law works, because this is principally what CDA is concerned about, defamation law. False statements. So what is defamation? It's a false statement that's made about another person that damages that person's reputation or otherwise causes harm. That's the short definition of defamation. A statement made about another person that is false and causes that person harm, usually in reputation, and that's defamation. Now, that definition includes anyone who makes the false statement. So if you are making a false statement about another person, that's covered. But what if you overheard a false statement about another person and now you're repeating it? Well, now you're making the statement. Now you're the one publishing it. You're repeating the lie. So even though you heard it from someone, you might be liable. And what if someone hears it from you and now they republish it? Well, now they're the publisher. So they're potentially liable. So everyone in the chain is liable no matter who they heard it from, because the law as it existed before didn't ask like who initiated the lie. It's just, did you publish? Did you proclaim a lie about another person? Was it false? Did it cause damage to their reputation? Well, I heard it from so-and-so. Normal law didn't care very much. It just said everyone is liable who repeats the lie. All right, so that's what you need to know. So then the internet came along. And we realized that that was not really going to work for us anymore because we had a problem. Because every time Twitter, if I make a statement on Twitter, I'm the one making it. Now Twitter is the one republishing it. They didn't create the statement. They are republishing the statement. So if we use standard run-of-the-mill law as it existed before CDA 230, Twitter is now on the hook for every single statement by every single person. Fun. So you can see why this didn't really work, because Twitter, how could possibly work without reviewing every single comment for its truth, and how could you even determine that anyway? So the law wasn't really built for this. So they came up with Section 230, which solved this problem. And I said, okay, if essentially in so many words, if you are the one republishing it, you're not on the hook. So if you're the one who wrote it in the first place, you're still responsible. But anyone else who's republishing it, who's just making it available, who's the publisher, is not liable. So it solved that problem. So it allowed Facebook to exist, allowed Twitter to exist, and for that matter, allowed every user forum and user base to exist, allowed every website with a comment section to exist, allowed all the bulletin board systems and all that stuff to exist. It's kind of a big deal. So there has been a proposal to reform Section 230 and try to improve it. So we went from a universe where literally everyone is responsible to a new universe where, unless you're the person who wrote it in the first place, no one is responsible. But maybe there's a way to make it better. Maybe there's a way to change this without breaking everything. And I think that is the most valid concern of all, because my view is this. I think it is a good idea to reform 230. I'd like to do it without breaking everything in the process. I'd like to do it without making everything worse. I'd like to do it in a way that maintains all the good 230 was trying to do and attempts to cure the bad in a way that doesn't make the patient worse. I'd like to cure the disease without causing more harm. Seems like a good idea. So can we do that? Can we improve the statute to keep all the good and get rid of all the bad? So we have a proposal from the Department of Justice who's given their shot at this, and we're going to read their proposal, and we're going to just try to figure out what we think. What are the good things? What are the bad things? What are the strengths? What are the weaknesses? And we're going to read the red line version. So we get to read two statutes actually simultaneously, because we get to read the original version along with the proposed version because it's a red line. You get to see the changes in context. Ooh. So we're going to look at this red line version and do 2 statutes basically for the price of 1. Super fun. So let's do that. Here is the law. The draft reforms to Section 230 of the Communications Decency Act. Very super exciting. Very super exciting. And we're going to read this and try to figure out what it has to say. So sections A and B are kind of fluff. They represent here is why we are doing this, and here is our hopes and wishes and dreams. So sections A and B, in case you're wondering why they're not here, are kind of inoperative. They're kind of philosophical. Here's what we're trying to accomplish. Here are the things that we find. You know, they only have value really to the extent that you're trying to interpret a absent provision or an ambiguous provision, because then you could look to the purposes as part of trying to interpret the intent of it. But if the language itself is clear on its face, we don't need to do all that. So we'll kind of ignore sections A and B for the moment, and we'll just go on to section C. So let's do that. Protection for Good Samaritan blocking and screening of offensive content. All right, section A. This is the old language. Treatment of a publisher or speaker. Old language. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So you're not the publisher of it, you're not republishing it, and you're not the person saying it. You are none of these things. You are not repeating the defamation, you're not speaking the defamation, you are just not responsible. That was the old law. But now we're going to modify that with some new language. Okay, great. So let's give that a try. So we want to add a new language. Subparagraph A. Shall not apply to any decision, agreement, or action by a provider or user of an interactive computer service to restrict access to or availability of material provided by another information content provider. Any applicable immunity for such contact shall be provided solely by paragraph 2 of this section. So basically, they kind of took it completely away. Yeah. So that old language doesn't apply by a provider or user to restrict access to or availability of material provided by another. So it doesn't. So it still applies. It still applies in full if you are merely repeating it. So if you're enabling the language, if you're providing the language, if you're doing it without censorship, you're still not responsible. But it doesn't apply if you're trying to restrict access. So this is kind of a one-way valve. So subsection A applies if you're allowing the tweet, and we'll just use Twitter as an example because why not? We'll just use it in the context of Twitter. Why not? So Twitter is our example for the rest of the day. And so it says, okay, subsection A, if you, Twitter, are providing this content to people, you are not the publisher or speaker. Only the people who actually wrote it are the publisher or speaker. Are you that thing? No. So you're not the publisher or speaker, so you're all good. Great. And then subsection B says, Twitter. This doesn't apply if what you're trying to do is restrict access to or availability of. If you're trying to remove content, that's covered by a different content. So if you're providing it, no problem. Immunity for you. If you're trying to restrict it, no, not so much. Okay, so that's what that's trying to do. Then it says, for the purposes of subparagraph A, no provider or user of interactive computer service shall be deemed a publisher or speaker for all other information on its service provided by another information content provider solely on account of actions voluntarily taken in good faith to restrict access to or availability of specific material that the provider or user has an objectively reasonable belief violates its terms of service. So that's a whole lot of language there. So if you're trying to restrict language, then subsection C kicks in. So you are not the provider, you are not the publisher or speaker. If you're taking actions taken in good faith that restrict access to or availability of, if you have an objectively reasonable belief, it violates the terms of the service. So when we're talking about like different perspectives, we can be thinking subjectively or we can be thinking objectively. These are our two options. When we say something is subjective, we mean in the mind of the person that's doing it. It has to make sense to them. That's a subjective belief. So it made sense to me if that's a subjective belief. By objective, we mean the ever popular reasonable man test. In practice, a jury. So we're going to ask, would a reasonable person believe this thing? Would a reasonable person of prudence and average intelligence and conscience, would this person believe it's in keeping with the terms of service? We're not concerned about what's true in your head. We're concerned about what the reasonable man thinks. And we use the reasonable man test all the time in law, all the time. Very common to use this reasonable man test. We think about it objectively. And then you're like, well, how do you determine that? As a practical matter, you ask a jury. That's exactly how you determine it. You get a whole bunch of people in a room and you ask them, what would a reasonable person think? And then the jury concludes, well, this is what a reasonable person would think. And yeah, so it's a consensus of a jury. That's how you do that. And we do it all the time in law. So that's what you're trying to do there. Civil liability. No provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user has an objectively reasonable belief. So the reasonable man, does the reasonable man have a belief that it is obscene, lewd, lascivious, filthy, excessively violent, promoting terrorism or violent extremism, harassing, promoting self-harm or unlawful? And then they crossed out the words or otherwise objectionable, because that's really a huge catch-all. Right? Otherwise objectionable is like, that's pretty broad. So they took away the catch-all. So now it has to fit in one of these discrete groups, which is probably a better way of going about it. That's nice. Hello, Nate the Lord. Glad to have you here. Which one, uncivil law, the subjective or objective test? The objective test is the reasonable man test. Yeah, the reasonable person test. The reasonable person of prudence and conscience is the objective test. Yeah, so then we're doing that. Okay, and then any action taken to make available to information content providers to others the technical means to restrict access to materials in subparagraph A. So if what you're trying to do is develop a bot or develop other sort of filtering software, that would be the kind of thing. Yeah. Okay, then we have this exclusion from this Good Samaritan law. So now we're going to take some of this away. Bad Samaritan carve out. Love the titling. Yeah. Subsection C1 shall not apply in any criminal prosecution under state law or any state or federal civil action brought against an interactive computer service provider. So you still can't sue under state civil law. You got that going for you. But state criminal law, no problem. So you need federal civil law. Okay. Which presumably means you need to find a deficit in the statute or a deficit of the application. So it's basically a negligent application of the statute, essentially. So you don't have any prosecution under state law or state or federal civil action brought about against an interactive computer provider if, at the time of the facts given rise to the prosecution or action, the service provider acted purposefully with the conscious object. So this is going to their mental state. So they acted purposefully. So they have to act intentionally is another way of saying purposefully. So they have to do it with the design and purpose. This is what they are trying to do. That's purposefully. I want this specifically to happen. With the conscious object, another way of saying intentionally, this is my goal. This is what I am trying to do. With the conscious object to promote, solicit, or facilitate material or activity by another information content provider that the service provider knew or had reason to believe would violate federal criminal law if knowingly disseminated or engaged in. So that's pretty specific. That's pretty specific. So you don't get this carve out if you are trying to purposefully. It is my goal and mission in life. It is what I'm specifically trying to do. You don't get the immunity if with that level of belief, you're trying to promote, solicit, or facilitate material by another that would violate the law. So you can't, with the design and goal of trying to do it, try to solicit it, material that would violate law. Is that consistent with the First Amendment? Good question. There will be much litigation over it, I am quite sure. Because as a general matter, you can encourage people to break the law. It's okay to encourage people to break the law. It's okay to say, it would be good for people to break the law. It's okay to, unless you're doing it imminently. Now, what's interesting here is that it's a carve out to an immunity that we didn't have to give you in the first place. So we didn't have to give you the immunity in the first place. So can we take away, assuming this violates the First Amendment, which is a whole nother problem, can we take away part of the immunity we didn't have to give you in the first place if the basis of it is unconstitutional? Good question. Don't know. That will be entertaining and I'm sure much litigated. Can we do United States term limits versus Thornton? Sure. I hope this one goes through. Tried to send on the Buck versus Bell. We did Buck versus Bell. We just haven't released it yet. But we have recorded it. Carve out for actual notice of federal criminal material. Subsection C1 shall not apply in a criminal prosecution under state law or any state or federal civil action brought against an interactive computer service if such a prosecution or action arises out of a specific instance of material or activity on the service that would, if knowingly disseminated or engaged in, violate federal law. So you have to know about it, which means that you have to have actual knowledge or presumably willful blindness. But if you're just doing things automatically, that's not knowingly. So it would only apply, presumably, if someone has brought it to your specific attention and you didn't do something about it. So someone has to alert you to it, or you have to know about it through some other mechanisms. It has to be knowingly. The process provider had actual notice of the material or activity's presence on the service and its illegality. Actual notice, again, was kind of like knowledge, basically. You actually knew about it. You actually knew. Or the provider failed to do any of the following, where it says and. Is this and or? Shall not provide under any state or federal civil action brought against an interactive providers if A, B, and C. Do they mean and or do they mean or? They say and, but do they really mean and? That might be a litigation question too. Not sure. The provider failed to do any of the following. Expeditiously remove, restrict access to, or availability of, or present dissemination of the specific instance of material and take reasonable steps to remove, restrict access to, or availability of, to present dissemination on the material of the across the service. So you failed to expeditiously remove. What does expeditiously mean? Good question. Not really sure what that means in the context of, say, Twitter, who has so many tweets. What does it mean to do something expeditiously? Good question. Therein reported the material or activity to law enforcement when required by law or is otherwise necessary to prevent imminent harm. So you have to do it, you have to report the material when required by law. Okay. And preserve evidence related to the material activity for at least 1 year, which presumably means you have to keep all your tweets, deleted or otherwise, at least available for 1 year to potentially legalize it, to potentially litigate about it. So yeah, that's pretty specific. You have to actually know. Someone has to put it in your knowledge. Actual notice of the presence, which presumably is kind of the same thing. It's a little bit hard to imagine how you would have actual notice and not knowledge, or the other way around. Okay, but yeah. And then you failed to remove the material expeditiously, whatever that means, reported to law enforcement if required by law, and preserve the evidence for 1 year so it's available for litigation purposes. Okay. Judicial decision carve-out. Subsection C1 and 2 shall not apply in any criminal prosecution or civil action arising from the failure of an interactive computer service provider to remove, restrict access to, or availability to, or present dissemination of, within a reasonable time, after receiving notice of a final judgment from a court indicating the material is defamatory under state law or is unlawful in any respect. So, if a court rules that it is defamatory under state law or in any respect, you can remove it and you're not liable. So, if a court somewhere says this is defamatory, regardless of anything else, so regardless of what your terms of service say, regardless of any other analysis, but if a court somewhere reaches a final judgment that's defamatory and you remove it, you're in the clear. Okay. No interactive computer service provider shall be held liable for removing, restricting access to, or preventing dissemination in response to such a notice. Fair? Yeah. Notice mechanism requirement. An interactive computer service provider shall make available to the public, without expense, an easily available and apparent mechanism for notifying the provider of the material. So now this is putting a burden on Twitter to notify the person who tweeted. of any activity as provided in those sections above. So if we remove your content, we have to alert you to it through some mechanism. So it has to be easily accessible and apparent, which, what exactly is that? An email probably would do. An icon on your, phone would probably do, but some way we're bringing it to your attention. Interactive computer provider shall not be entitled to assert immunity under the law if it designs or operates the service to avoid receiving actual notice of federal criminal material on its service or the ability to comply with the requirements. So you can't assert immunity if by design or by operation you are avoiding receiving actual notice. So if we give you actual notice, you have to operate in a way to receive it. You have to have some mechanism for us to deliver it to you. If you're purposely operating your service in a way for us not to give you notice, that would what would be called willful blindness. This is basically a willful blindness provision. So when we talk about knowledge, we can talk about actual knowledge, and we can also talk about implied knowledge, and we can also talk about willful blindness, which is another thing, which is where you're purposefully preventing yourself from knowing. And this is the purposely prevent yourself from knowing section. So if you say, aha, I'm going to be clever, I'm going to prevent myself from getting actual notice by designing it so that I don't actually ever see it. Well, another way of phrasing that is called willful blindness. I am purposefully preventing myself from gaining the knowledge that would make me liable. And so the DOJ thought of that and be like, no, not so much. If you have willful blindness, you can't get immunity there either. No, that won't work. $5 from John Woolley, who says, do you think the contents of the act match the ostensible intentions? How likely is Google and Facebook wrote the bill? I can't speak to that. I mean, it was written by the DOJ, so it is possible and even somewhat likely that Facebook and Twitter were at least asked about stuff and may have contributed to it. I mean, the DOJ does want to get it right. So it wouldn't surprise me if Google and Facebook were involved in its creation and some of the language. But, the degree to which this is written by, I wouldn't go that far now. Obligations of an interactive computer service, so that remains the same language as before. You have to, this is old language. It says that the provider, $2 from Roland, expeditiously means swift, fast, hurriedly, quick. What does that mean legally, Roland? I know what it means in English. What does it mean legally was my point. I wasn't asking what the dictionary definition meant. I was saying, what does that even mean? That was me saying, what does it mean legally for something to be expeditious? I'm sorry that somehow I failed to make that abundantly clear. I know what the word expeditiously meant. Yeah. Oh, man. So the old language said a provider or interactive computer service shall, at the time of entering an agreement with a customer for the provision of an interactive computer service and in a manner deemed appropriate by the provider, notify the customer that parental control protections are commercially available that may assist the customer in limiting access to material that is harmful. Such notice shall identify or provide the customer with access to identifying information. So we have to alert you to any parental control stuff that we would have. Effect on other laws. No effect on criminal law. Nothing in this section shall be construed to impair the enforcement of Section 223 or 231 of this Act or Section 110 or any other federal criminal statute. Which I'm not really sure why we need to say specifically those particular statutes when we're just going to say any other statute. All the statutes. Why did we need to say Section 223 and Section 231 and Section 110 when we said and all the other things too? So it doesn't apply to any federal criminal law. That's super informative. Nothing in this section shall be construed to prevent, impair, or limit the enforcement by the United States or any agency of any civil, federal statute or regulation. Fair. So if there's another civil statute or regulation that needs to be enforced, then they need to enforce those too. And to the extent that there's a conflict, then we're in some sort of conflicts of law analysis, which is super fun. No effect on intellectual property law. This doesn't pertain to IP law, so they're still responsible for copyright infringement. State law, nothing shall be construed to prevent any state from enforcing state law that's consistent with this. No action can be brought and no liability imposed on any state or local law that's inconsistent with it. Fine. Nothing in this section shall be limited to the application of the Electronic Communications Privacy Act or any amendment. Yeah. No effect on sex trafficking. We all know about that. No effect on anti-terrorism law. Nothing in this section shall be construed to prevent civil action brought under Section 233 of Title 18. Did they already say all the civil law too? Or how was that written? No, I guess it wasn't. So now, yeah, we have nothing. So nothing. It doesn't deal with civil law for anti-terrorism. Doesn't deal with civil law for child sex abuse laws. It doesn't deal with civil laws that relates to cyber stalking. So if it's cyber stalking, you don't get liability protection there. How Twitter is supposed to determine that on the fly could be problematic. No effect on antitrust law. So yeah, it's unclear how CDA 230 would, on its own face, deal with antitrust law. I'm having a hard time seeing the connection between those two things. But yeah, I guess to the extent that there's an antitrust law violation, you can still go them after antitrust. Not sure why you couldn't anyway, but let's throw that in there, sure. The term internet means internet. The term interactive computer service means interactive computer service. The term information content provider means information content provider. The term access software provider means exactly what you think it means. And then we have this good faith section. To restrict access to or availability of specific material in good faith. So when we had that language above that said in good faith, remember that from way above when we talked about objectively reasonable good faith. So let's scroll just all the way back up to the top so we can remind ourselves of the context of what that is. So we're back up here. We're back. Let me go back to the top. This is the civil liability section. So any action taken on good faith to restrict access to or availability material, the provider or user has an objectively reasonable belief is any of these things. So we know what objectively reasonable is, that we use that in the law all the time. The reasonable man test, ever popular. So we know what it is to have an objectively reasonable belief. But what is good faith mean? What does it mean to have good faith? Because that's not a well-known legal term. Well, no problem. The Department of Justice has you covered. So you have to have good faith, which means exactly this because we're about to define it. Yay. To restrict access to or availability of specific material in good faith, this is what you have to do. This is what it means to have good faith. Okay. You must have publicly available terms of service or terms of use that state plainly and with particularity the criteria the service provider employs in its content moderation practices. Okay, so you have to make users available. It has to be publicly available what your content moderation policy is. So you can have any policy you like, which is something I approve of. You can have any policy you like, but you have to make them clear and with particularity. What exactly does it mean to be particularized? That's a good question. Because how particularized do you have to be? How clear do you have to be in your content policies to make it particularized? So that's a good question. And they also, to the extent it has to be plain, is a bit of a problem with particularized, because if we really want to be plain, then we might have to go into a lot of verbiage, which may not be particularized and also not necessarily clear. So what does it mean exactly for the content provisions? And this is a legal question before you give me a dictionary definition, incidentally, chat. What does it mean for something to be particularized in a content use policy? I mean, if I were trying to draft this on behalf of Twitter, then I would at least give some examples of things that would qualify and try to make it clear that way. Would be one way I try to get around this or deal with this. But that's a good question. You must also restrict access to or availability of material consistent with those terms of service of use and with any official representations or disclosures regarding the service provider's content moderation practices. I like this very much. You have to restrict your content consistent with two things. You have to restrict it both with your formal terms of service and with your official representations. So you can't speak out of both sides of your mouth. You can't say, well, we believe in free speech. We believe in free expression. We want all the things, to be said, and then try to bury it in legalese. No, the Congress thought of that, and very clever, or DOJ thought of that, and very good for them. It's like, no, we're not going to allow you to make public statements that are inconsistent with your terms of service. You can't go out and proclaim yourself a free speech bastion and then bury it in terms of service that, by the way, no, we're really not that. No, you can't do that. You have to moderate both consistent with your legalese and your official representations. So if you, Twitter, through your official channels say, we believe in free speech, well, you better moderate consistent with that, because regardless of what your terms of service are, so you can't make so this is basically just, you have to be truthful in your statements. And since this is commercial speech, that seems fine. You just have to be truthful. You can't lie. And since it's commercial speech in nature, intermediate scrutiny, so that seems fine. But I do like that very much. You cannot restrict access to or availability of material on deceptive or pretextual grounds. You can't say, I'm doing it for this reason when you're really doing it for another reason. Or apply, which again goes to truthfulness. You have to be truthful in business. Congress can insist on people being truthful in business. That's fine. So you can't do it deceptively or pretextually. Or apply its terms of service to restrict access to or availability of material that is similarly situated to material that provider intentionally declines to restrict. Similarly situated. So it doesn't have to be identical, which would be pretty hard. It has to be in a similar posture. It doesn't even say substantially similar, which is amazing. It just says similarly situated, which is kind of low. If it said substantially similar, that would be, a little bit tighter. But similar is just like basically more likely than not, essentially. So if you restrict access, or rather you don't restrict access, because you only get in trouble for restricting stuff, mind you. That's the only reason you get in trouble, is restricting stuff. So if you choose to restrict some stuff, you can't restrict other stuff deceptively on pretext, or restrict access or restrict it if you didn't do it. So you have to be consistent in your own policies. You have to apply your own policies, which you're allowed to have any policy you want, but you have to apply them consistently for everybody. You have to actually mean what you say. That seems okay. I mean, I have no problem with that, because again, commercial speech, intermediate scrutiny seems okay. And you also must supply the provider of the material with timely notice. So again, this is the person who tweets. You must supply them with timely notice describing with particularity. Again, what does it mean to be particular? How particular does it have to be? Presumably you have to say at least what particular rule you're violating. So that'd be nice. So they can say why that does, the provider's reasonable factual basis for the restriction of the access and a meaningful opportunity to respond. So you have to give me a chance to respond in a way that you'll actually consider, because that would make it meaningful. Unless a law enforcement agency has asked the notice not be made. Okay, that makes sense. So if it's part of a criminal investigation or something like that, and they say, would you mind not giving the notice? You can restrict notice there. Or a provider reasonably believes the material relates to terrorism or other criminal activity, or such a notice would risk imminent harm to others, which again goes to the cyberstalking. So if it relates to this terrorism or criminal activity, you don't have to give notice. If it relates to imminent harm of others, which is cyberstalking basically, you don't have to give notice. Otherwise, you have to give them a reasonable opportunity to reply. What is pretext? Someone asked in chat. Well, pretext is just basically, I'm saying I'm doing it for one reason, but I'm really doing it for another. So to give an example of this, what would be a good example? You can even think of it in your daily life. Suppose you wanted to talk to a friend about something. You basically want to stage an intervention. Suppose you want to stage an intervention for a friend. So you're probably not going to say, please come over so I can stage an intervention for you. That would be the real reason. You'll probably say something like, please come over. I'd like to hang out with you and have drinks with you. That would be the pretext. You know, I'm doing it for this reason, but it's not really my reason. I'm doing it deceptively so that you will agree to me. So like the real reason I banned your speech, to go to the statute, the real reason I banned your speech is because you're conservative and I don't like conservatives. But I can't say that because my policies say free speech. So what I'm going to say is, oh, it related to one of the protected reasons. The reason I did isn't because you're conservative and I don't like conservative speech. I like conservative speech just fine. I did it because it was obscene or lewd or lascivious or filthy or violent or promote terrorism or harassing or self-harm or unlawful. That's my reason. That's a pretext. You're lying about your real reasons, you know? Yeah, there you go. That's good stuff. So yeah, there's a lot of stuff here. To the best of my knowledge, because there's a debate about what obscenity is. Obscenity is a pretty hard thing to find legally, because it has to both relate to the prurient purpose, and it has to have no artistic merit to it. So it is pretty hard to get there. Obscenity is pretty hard to find in U.S. law. Is very rare to find something to be truly obscene, at least under the modern jurisprudence. So yeah, I wouldn't worry about it too much. Obscenity is pretty hard. Let me see if I can find the actual definition of obscenity from the Supreme Court so I can quote it to you, since this is a legal education channel. Hold on, I'm going to find the definition real quick. Why guess when I can just quote it? Yeah, Miller versus California. That's right. All right. So here is the standard for obscenity. It has 3 parts. 1, whether the average person applying contemporaneous community standards, so the average ordinary person of ordinary talents applying contemporary community standards, so the community in general, how they would feel under as it exists right now. So this is ever changing. Things can become obscene or not obscene depending on when they're published in the community, also incidentally. But this average person, as the community would agree, and again, ask a jury because that's how you would know, they have to find that the work taken as a whole applies to the prurient interest, which incidentally isn't that hard. I mean, if we're trying to figure out whether it applies to the prurient interest, you know exactly what they're talking about, you know? So that's yeah, not that big a problem. So that's 1. Is it prurient? Number 2, whether the work depicts or describes in an offensive way sexual conduct or excretory functions. You know, that would be you know exactly what it means to excrete things. You know what they're talking about. If it depicts or describes in an offensive way sexual conduct or excretory functions as specifically defined in a specific state law, so it has to be defined in the state law that way. And then number 3, and this is where it pretty much fails universally, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So it's kind of hard to meet those tests, so I wouldn't worry about it too much. I'll just go back to full screen because why not? But that is what the standard is. It's pretty hard to get there. Now, when you're thinking about community here, because someone asked, is hentai within the hentai community? No, that's the wrong community. When we mean community here, we mean real world community. We mean the community of the town, city, state, or whatever it is that's governing this. So when you say community, no, we don't mean hentai community. We mean city of insert blank. That community, the real world, the big community. They're the ones that have to justify this. But I wouldn't worry about it too much because you'll get to artistic merit pretty easily. Number 5 from John Woolley says, where did the whole neutral public forum debate come from? Just looked up the original. I didn't see it. Did Ted Cruz just make it up? I mean, it isn't in CDA 230, that's for sure. And the authors of CDA 230 have said that wasn't really their goal, and doesn't seem to be their goal from the statute. Now, whether or not we should have neutral public forums, that seems to be what they're trying to accomplish from this language, and seems at least promising. I've seen some problems in it, but it's not a bad idea. Yeah. Yeah, that Chad is giving me some decent examples. Thank you, Chad, for adding to the mix. But you've got at least the right idea. Yeah, I got at least the right idea. See some other chats. Hello, Tony Neves. Glad to have you here. Dustin, A. Hedinger, GG, Roland, Steven. Is expeditiously for Twitter if they do it in 1 week, 30 days, 3 months? Don't know. Good question. GG says too much can happen in 30 days. Even though that's true, like, what does it mean for them to act expeditiously, especially when everything is moving so fast? Making available the exact policies and procedures used for content moderation is a very bad idea. Well, I don't know about that, but we're trying to have things be consistent, and we're trying to apply them consistently. So I don't know how bad an idea it is, but there is also incidentally, how it might impact me as a YouTube creator is interesting, especially on the live chat, right? Because if I remove content or I time people out or all that stuff, presumably that also applies to me. So that means I have to be a lot more specific in my policies, which is super duper fun. Yay. Didn't Dems block this? I don't know if they blocked it or not. It's just a proposal right now. And I wouldn't expect it to pass anyway, right away. It needs debate. It needs more review. So I don't know if the Democrats have blocked this or not, but I wouldn't expect it to pass in any regards. Dustin Rodriguez, Stephen Rankin, nice to have you. Ernet Commentator, glad to have you here. A. Hedinger, Joshua Taylor, pressing charges on the Mikulskis because they were brandishing weapons. We take that seriously, not because of any ideology. Yeah, that might be an example of pretext. Yes. Shakespeare wouldn't qualify just because it's been around so long and it's been adopted into the canon. So, things might be obscene today and not obscene tomorrow as society develops. So, there is that. It's an evolving standard as society evolves. So, There's a bug in our legal system. 500 plus people whose job it is create new law, 9 people who can effectively get rid of them, and no penalty for reintroducing next session. Well, let me give an example from my field to show you what it is, or why I say it's not that big a deal. The Patent Reform Act, which is part of my daily job, which is now known as the American Invents Act. They changed the name, but the Patent Reform Act was proposed 6 years before it became law, and was reintroduced and went through committees and debate and discussion and all that stuff, and hopefully made the law better in the end. So just because a bill fails in any given year doesn't mean that it shouldn't be reintroduced, because, well, the bill wasn't good enough to pass, so let's bring it back and have more discussion. And so, to me, it isn't that big a deal if this is introduced and fails, and then is brought back and fails, and brought back and fails, and brought back and fails, because hopefully every iteration of that The language is getting better. There's been more debate, more discussion, more thought about it, and I'd like to get it right. So I think you might be at least partially missing the legislative process and how it can sometimes go, and how sometimes it takes a long time and a lot of iterations to make sure, before we change something. I mean, with the Patent Reform Act, we're trying to change something that had been around at least since 1952, and depending on your view, a lot longer than that. So before we break arguably 50 or 200 years of patent law, let's think about it a little bit. And, before we break the internet completely, let's think about it a little bit. That's kind of where I am on that. What is literary value? I mean, you know what something is to be literary. If it has value as a text, if it has value for its prose. I mean, ultimately it's judged by the reasonable man test, but there you go. Will ACB's pick hurt Trump's appeal with suburban women? Couldn't say to that. Yeah, then the knowing persona points out, and I think this is a good point, it's not a bad idea having policies available. It would be like arresting people without having laws available. I mean, good point. I think that's at least comparable. Obviously, the penalties in criminal law are a lot different than the penalties in whatever this is. I mean, your content gets removed versus you go to jail. But at least the idea of having policies and printed and then people trying to get around them, well, people do that in criminal law all the time to varying degrees of success. But yeah, to have the policies clear and on their face, it could work. Why not reintroduce the identical bill? Maybe we should have the identical bill, because just because it failed the first time, maybe it failed because we haven't been persuaded yet. Maybe we just need to have more testimony. Maybe we need to have more people opine about it. Maybe we need to have more people offer their intakes, and we need to reconsider it. So even if we wind up eventually passing the same language, presumably it's because we had more time to think about it. It's because we've had more debate, more discussion, and we've decided, yeah, that language is the best language. We weren't convinced yet. Oh, now we're convinced. So again, even reintroducing the same language doesn't, to me, signal a defect in the process. It's just like, well, we're not persuaded this is the right language yet. I'm not even persuaded this is the right language. I mean, I think it's good, but I definitely want more discussion, more debate. If I were a member of Congress, I'd be thinking, yeah, this is kind of what I'm looking for, but I don't know that I can vote for it now. I need more discussion, more debate before I'm ready to pull that trigger. So I might vote against this today and vote in favor of it 4 years from now. And I don't see how that's bad, because presumably in that 4 years, I've had more time to think and more time to talk to people and more time to really weigh the consequences and more time to hear testimony, more time to hear from all the constituents, more time to do all that stuff. And it's like, yeah, I'm convinced now. I think it's okay. So I don't even see the problem with it, really. Lagomorph says it's so nice for you to be optimistic on how Congress works. I try. I try. Hoglaw covered this. He liked the beginning but disliked the end. I mean, I saw some weaknesses there too. I don't think it's perfect. It's a good place to start. The language might be improved. There are problems. And anytime there's any vagueness in statute, then, using Chevron Hour Brand X, that means that some agency somewhere, whether it's the FCC or the FTC, can issue regulations on this. So, when they're passing regulations on this, that might be a problem. Maybe we need to tighten it up in the statute, so we don't leave this to the administrative state to figure out the problems in between. So yeah, I mean, I'm not saying it's perfect. I'm saying I think it's good. It's a good place to start. Stephen Rankin points out they ban some people for violating the rules, but not ban others for violating the rules because they make money or have following. Yeah, that's not fair. If you're poor and don't understand how the legal system works, you often go to plead a crime you've never been convicted of. That's definitely possible. Sure, a lot of people plead for a lot of reasons, not all of which are noble. Yeah, because FCC is a department within the government, it falls under the executive to write their policies. Yeah, FCC or FTC would be presumably the ones who would have jurisdiction over this. What I'm worried about is they want to term limit SCOTUS. I'm not worried about that as long as they want to do it in a fair way. If they want to change it to 18-year terms and stagger them or something, that would be fine by me. Thomas Lupus says, ever thought about running for office? Maybe. I do live in Texas. I could run as judge because that's a thing I can do here. That known persona says, there was a case in your now home state involving obscenity. Seems to be a case of injustice. The individual charge was essentially only the cashier. The business is not charged. Yeah, fair. That's a very fair critique and criticism of that. I couldn't speak to the exact issue, but that sounds problematic at best on its face. €5, I'm assuming, from Roland. Since Japan has a very different standard of perverse and the internet is worldwide, how do we keep from sliding to the lowest point? Well, when we talk about obscene, this is U.S. law. It's judged by the U.S. law. So what any other country in the world would deem obscene is kind of neither here nor there, although it might be slightly informative. But it's an issue of whether it's obscene under U.S. law. So what's going on in Japan is interesting and might even be informative. But at the end of the day, the community standards are the community, which is to say the city of whatever, county of whatever, state of whatever. Those are the relevant standards. So, so the American law applies to American speech. So, there's that. I think the system is close to perfect, but we need an anti-Congress. The job is solely to repeal laws. I'm definitely sympathetic to that. I think that's actually a good idea. There should be someone somewhere on some level that is proposing repealing of laws that are old or outdated. There should be an administrative body within Congress. If I were doing it, I'd do it as an administrative body within Congress whose sole mission in life is to propose statutes that need to be repealed because they're old or out of date or no longer applicable, and clean up the code. Good idea. I'm down for that. I didn't understand with the intent of this revision until I realized like the 230 never said what some of the GOP claimed it did. It's pretty foolish thinking there was a neutrality requirement. Yeah, there wasn't a neutrality requirement in the original 230. In fact, the original 230, if you look at it in context, the Communications Decency Act, the whole point of the entire Communications Decency Act was to create decency, which is to say, not having speech that was considered offensive. The whole point was to allow people the latitude to take away stuff that was bad. It was not intended to be neutral. And when we're thinking about decency, incidentally here, the people who are passing it are like Christian Republicans. So that would be bad from a Christian perspective, more specifically. So was it designed to be neutral? No, absolutely not. It was not designed to be neutral. It was designed to allow people the flexibility to apply their own conscience. Well, that's been a problem, and I think it is a problem as we've gone and applied this, because now we have these really big companies. Because remember, in the early days of the internet, things were more chaotic, and now we have these really big companies, and so much speech is flowing through them. It's become a problem. I think it is a problem, and so why should Twitter have the ability to determine what the rules are for all the users of Twitter, which is quite a lot of the social speech? That's a problem. And so now we're trying to address that problem by saying, well, you can have any rules you want. You just have to be honest about them and apply them fairly and evenly to everybody, which is unobjectionable to me on its face. Some of the language is problematic, but the fundamental idea is right. You can have any policy you want. I like this a lot better than Robert Barnes' idea. I don't think I'm misquoting him. I think Robert Barnes said this, and if he didn't, I apologize, because I think he said it, but maybe I'm wrong. But I think the way he phrased it was, he said, well, they should just have to apply speech as it would be understood in the Constitution. I'm like, no, that goes too far. That goes too far, because the government can't restrict a whole bunch of speech. And some Christian website somewhere should not be forced to have comments on its own webpage that go completely and directly against its philosophies. So the idea is like, hey, just to make them abide by the First Amendment. No. That doesn't work. No, that doesn't work. But here, it's simply saying you have to be consistent with yourself. You have to be, this is basically just be honest in your speech. And that's intermediate scrutiny for commercial speech. Commercial speech can be forced to be honest. Be honest in your speech. Just be an honest person in your speech. So all we're saying is have a rule set. Be honest about your rule set. Make public statements that are honest. So don't try to go out there and deceive people about what your rules are. Make statements that are consistent with your rules. Be honest in your speech. Be honest in your rules. Be honest in your speech. Apply them honestly, evenly, to everybody. You can have any rule you want. Any rule you want. Just apply it evenly. You could even have a rule that says we don't allow Republicans on here. That's fine. We don't allow any conservative speech or any Republican speech. This proposal doesn't ban that. This allows you to have bias rules. It can say, you know, I don't want conservative speech. I don't want Republican speech. I don't want any speech that tends to show Donald Trump in a good light. You can have that policy. Just be honest about the policy. And then, you know, that go from there. And so since this is fundamentally going to be honest in your speech, and we're talking about commercial speech, you know, I think it passes constitutional muster is my initial impression. There's some constitution. There's obviously some legal problems in here. There's legal language that's problematic. I've already highlighted some of those issues, and not that I spotted every issue, but there's some potential problems. There's even potential constitutional problems. But on the whole, at least the fundamental idea seems constitutional, even if not the exact language they wrote. The fundamental idea is just be honest. And this is commercial speech. You're a commercial provider. Be honest in your speech. The government can make commercial providers be honest. That's one of the things they can definitely do. So no problem. $5 from Curtis Jones. Thank you for the super chat. If there's a company based in another country that has business in the USA, could the 230 lawsuit be enforced against them? Yes. Because the speech is in the USA. Yeah. Because the speech is in the USA. And you have to apply with our rules. John says we're on Team Uncivil Law, not Team Barn Law. Fair. Are we always talking about commercial speech? I don't understand the question. What you're asking me. Are we always talking about commercial speech? When we talk about commercial speech, we're talking about speech that is commercial in its nature. So it's not commercial because it is said by a commercial provider. That is not what makes it commercial. So just because it is said by a commercial provider is not what makes it commercial. What makes it commercial is that it goes to a commercial nature by a commercial provider. So I think this is commercial speech because Twitter is providing a service. They're providing a service. It's commercial in nature. They're running it for profit. I mean, that makes it commercial, right? So they're running a service, and it says just make your term of service honest. Right? Your terms of service is commercial speech. It is commercial in its nature. It is commercial in its nature. It's saying here is how to use our commercial service. That makes it commercial speech. Here are the rules for using our commercial service is pretty fundamentally commercial in nature. Here is what our platform is. That's pretty commercial in nature. You know, we are applying our own rules. That's commercial in nature. You know, it's fundamentally commercial. So no, we're not always talking about commercial speech, but everything this language is directed to commercial speech as far as I can tell. At least on first impression, I think so. Defending the Strawman says the biggest problem is you can't meet the requirements when you use an automated system. So cost of compliance. Can you use an automated system? Maybe. You'd have to be a lot smarter about it, but you know, you might be able to use an automated system and get away with this. You know, you just have to be even about it and fair. Drudge is reporting ACB got pet. That does seem to be the things. Well, if I put up my blog and I have a comment section, is that still commercial? Depends on what your blog is, I suppose. But I would say fundamentally no, because the comments are not from you. So that would automatically make it not commercial in nature. So no, because you're not the speaker. Commercial speech it's only from the speech of the commercial provider. So if you have comments, it's hard pressed for me to see how any comment that comes from someone outside your company, it's hard pressed for me to see how any comment that's left by a user would be commercial in nature, because it's not being said by the commercial provider. It's being said by some rando. So I think it's kind of categorically not commercial speech. So you should be fine. Can I explain jury nullification? I sure can explain jury nullification. So jury nullification is pretty simple. It simply says that if a jury reaches a not guilty verdict, then that is binding, no matter what reason they reached it. It's because we don't look to what the jury did. So the jury nullification would be a jury saying, this law sucks. And even though we have been told to apply the law, and even though we swore to apply the law, and even though the law requires us to do this, how about no? How about no? How about we're just not going to do those things? We are not going to do those things and reach that conclusion. We have found the relevant facts. We are the jury. We have found the relevant facts. And the facts as applied to this law counsel this result. And we're supposed to do this thing, but we're just not going to. We're just not going to because we don't want to. We don't want to apply it, therefore not guilty. That's jury nullification. It's the jury saying this law sucks in this circumstance and we're just not going to do it. That's jury nullification. Now that comes with both good and bad, right? It can be both good and bad, because it can be good if they are, it depends on how sympathetic we all are to the person, right? So it probably wasn't so great. Jury nullification probably wasn't so great when it was being used, by the antebellum South or something, or even the post-war South, during Jim Crow, to let good old boys off when they were murdering people and lynching people. So not so great when the jury was ignoring the law to let the lynchers off, even though they knew they did it, they didn't care and didn't want to do it. So, jury nullification isn't always great. It comes with some negative consequences. It can be used both for good and ill. It can be used for the jury to say, we don't want to apply it. And maybe that's the right decision somewhere, but it definitely has its problems. But that's jury nullification for you. It is the jury collectively making the decision of, we have sworn to do this. We're supposed to do this. We found all the reasons to do this, but no, we're just not going to. And since you can't look into the jury box, since the sovereignty of the jury is intact, there's nothing you can do anyway, because you can never find out about it. And if you could, no one would ever prosecute you. So that's jury nullification. If off topic's okay, that what does non-obvious mean in patent law? Oh, Jesus Christ, man. I mean, that's not an easy answer, man. That's hard. That's hard. That's really, really hard. It's not easy to summarize that, because I know so much about it. That's part of the problem. I know a lot about it. It's really hard for me to give an answer. But yeah, the shortest possible answer I can give you, which is in no way correct because it's so short, but it's the best I can do. Non-obvious is if you have a practitioner in the relevant art. So so someone has invented a thing. And so now you're looking at someone else, not the inventor, some other person who's in the same field of endeavor, which depending on what you're doing might be very, very narrow, because you have to look at, so what the field of endeavor is a whole problem, because what does that mean? I mean, if it's a computer-related invention, does that mean, for example, all people who do computers, or is it all people who do software? Is it all people related to memory management? Is it all people related? So how narrow is the field is a problem. But hypothetically, you ask this person if they exist, and if not, you construct one in your mind. So you construct one, even if you construct this theoretical person, and then you ask this theoretical person, given all the knowledge of all the art that exists, would this thing be obvious to do? Would it be something that be like, of course you would do that? That's obviousness. Actually applying that, though, is really, 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 really hard. Thank you for the impossible to answer question. That was super fun. Apple or Amazon or someone got a patent on a white rectangle. So the idea of non-obvious is ludicrous. That was a design patent. That was a design patent, not a utility patent. So when I answered that question, I was answering it for a utility patent. Design patents are a lot more narrow. They're a lot more narrow in function. So it's a lot easier to get a design patent, and it's also a lot harder to infringe it. So the answer I gave was for a utility patent. For a design patent, it's almost never obvious, because how can you say that one design, because you're talking about artistic creativity, right? You're talking about how something looks rather than what it is. So how can you say like one drawing is obvious in light of other drawings? How can you say this new thing is obvious in light of all the other stuff? So unless it's like identical, which then you don't need obviousness. So unless it's identical or really, 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 really close to something else, then no, it's not obvious. But by the same token, it's really, really hard to infringe it. So Apple's design patent was completely valid, and to get around it is really, really easy. I think theirs was for like rounded corners, and then just like don't have rounded corners. I mean, it has nothing to do with its functionality. It has to do with what it looks like. So that's why that patent was issued, because yeah, that's a valid patent, and it's just really narrow, and it's really hard to infringe because it has to be basically identical. So yeah, infringement is really hard. Getting it is easy. Infringing it is really hard. It's attractive, however, though, because the damages are really attractive. So if you can actually prove design infringement, then you get some wonderful damage remedies, which is really nice. But that's, yeah, design. And also, incidentally, there's a third type of patent. So you have utility, you have design, and then you have plant. As in the things that grow from the ground. You can get patents on plants. I know literally 0 things about plant patents. I assume Monsanto gets some of them. I have no idea what it takes to get one. I have no idea what it takes to infringe one. I have no idea how they're processed. Plant patents are very rare. I don't know how rare they are, but they're like very small part of the patent office business. Very small part. But if you want the thing that grows from the ground, the plant, that's an option too. Ask a botanist. I'm not that. Curtis gives me $5 to say thank you for answering. No problem. I'm happy to help. Yeah. Dustin says the people were saying Apple patent was too broad to be useful. Yeah, no, it's fine. It's totally fine. Do any movies or TV shows depict the legal system well? I mean, on the whole, I'm a fan of Law and Order. It's a little bit idealistic in some of the things. It makes a lot of like things that probably wouldn't happen in the real world. But like, if you're willing to suspend disbelief and assume certain things would happen, then for the most part, it then follows what they show on the screen, but not always. So it's a little idealistic in the way it constructs the story, because real stories probably wouldn't unfold that way. But if you ignore that and just assume that the story is the legal result they usually come to is usually pretty good. So Law and Order, I'd say, is pretty good. My Cousin Vinny is obviously good. Really good examples, some cross-examination there. Really good examples of expert witness handling. My Cousin Vinny is really good. Personally, I'm not a fan of A Few Good Men. I think A Few Good Men actually sucks as a legal movie. Personal opinion. Most lawyers would say A Few Good Men, but I won't. I don't like A Few Good Men. I don't think it's very good in the law at all. Yeah. Where is the Constitution regarding jury nullification? It's not in the Constitution. It's just a natural consequence of the nature of the system. So, it's if you want to say where it is in the Constitution, it's the double jeopardy clause of the Fifth Amendment. That's where it is. It's the double jeopardy clause. No person shall be held twice in jeopardy for any offense. That's where it derives from. So once the jury says not guilty, regardless of the reason they did that, that's where it comes from. It just comes from it comes from the double jeopardy clause. So that's where it is. It's embedded in that. Are there any good 2 Amendment arguments against the National Firearms Act? I don't know the National Firearms Act in total, and so you'd have to be a little bit more specific on the National Firearms Act. But at the moment, probably not, because the case law is nowhere close to being able to go after the National Firearms Act. It's just not there. We need a lot more precedent to even begin to think about going after the National Firearms Act. And the Supreme Court has been more than a little bit. It's been very frustrating to me. The Supreme Court needs to develop the Second Amendment law. First, what we need is a case saying that there's a right to bear, either concealed or open carry. That would be great. How about a right to bear case of any variety that says some version of, yes, you can have a right to keep and bear arms concealed or open, at least under some variety of circumstances. How about that? That'd be a really good place to start. And then once you have that case, which you really need, then you can start thinking about developing on top of that. So then you can start to thinking about expanding and developing on top. So then you could say, well, okay, Heller talks about right to keep in the home. How about maybe right to keep in a car? Maybe that would be the next logical step. Or how about replace a business? That's actually better. How about replace a business? That's actually better than a car. A car raises problems under the Fourth Amendment too. So how about replace a business? That might be good as the next case to follow Heller. And then once you have a right to keep and bear arms of some variety, depending on what the court, decided in that case, then you would expand it to the next logical step, and so forth and so on. But yeah, we're nowhere close to being able to challenge the National Firearms Act. What I think the Supreme Court should be doing is taking like 5 Second Amendment cases a year. That'd be good. How about that? I mean, they usually hear like 1 or 2 or 3 First Amendment cases every year. And the Second Amendment law needs a lot more development. How about a case dealing with gun ranges? How about that? How about a case from somewhere that a city has tried to ban gun ranges, and then how about no, not so much? How about that case? How about that decision? That would be good. I mean, there's lots of avenues to develop the law, but you need to do it step by step. We're nowhere close to it. So yeah. Woody Miller says, is it true when you pass the bar exam in Texas they issue you a hat and gun? I hope so. I'm not admitted to Texas. I'm admitted to Virginia. I moved to Texas relatively recently. I'm not admitted here yet. I'm still practicing on my patent law license, which is federal. So I don't know yet, but I'll get back to you on that. Jury nullification has been around for a long time. I even argue it's unwritten inheritance. Sure. Castillo versus Texas. Can you give a short opinion and provide your opinion? Woof. Let's see about that. Castillo versus Texas. Let's see. No opinion on its face. No opinion on its face. And I don't know why they didn't go after the shop owner, but yeah. Internet commentator says, I couldn't find you in the Virginia bar. That is true. You cannot find me in the Virginia bar because the Virginia bar allows you to not publish your name in the Virginia bar, which is what I've chosen to do. You are correct. I am not on the Virginia bar page because Virginia is a state that allows you to restrict your own publication in the directory. And I've restricted it. But if it makes you feel better, I see if I can find my bar card. I think I have it. One second. Give me 1 second. I'll see if I can find my bar card. Hold on. Let's see. Yep. Here's my bar card. That's what it looks like. In case you want to know, keep my information off the site. But yeah, there's my Virginia bar admission card. Super exciting. Yeah. It's people don't think you're a lawyer on r/law. You have a lot of alcohol. Well, why would people on r/law think that would prevent me from being a lawyer? People in r/law should know that the alcohol addiction rate for lawyers is about 3 times the general public. So the fact I drink a lot of alcohol makes it more likely for me to be a lawyer, but super, super fun. Yeah. I can show you one more thing too to prove my bona fides. Hold on. You guys know how I go by Blackleaf a lot, right? So I go by Blackleaf31 on Reddit. Not that I comment there a lot, because this won't make sense unless I give that disclaimer. And what the hell? I don't care. I'll just show you the thing. No, I don't want to give out my credentials to anyone who doesn't know them. Let's see. Where can I find? Let's see if I can find this thing. Yeah, okay. Yeah, that's what I need. So let me add a browser source. This will be entertaining as I try to do this on the fly. Good times had by all. Let me see if I can do this without completely screwing it up. And so I need to replace this. No, I don't want to filter it. I want to display something else. Yeah, that's what I need. Yeah, that's what I need. There's my bar admission for the U.S. Supreme Court. If you saw Robert's stream, or you saw me and Robert on stream yesterday, you might have noticed this in the background of the shot. I noticed it because I noticed immediately what it is. So if you go back and watch my live stream with Viva, you'll see this exact thing on Barnes's wall, because he had the same one. I'm like, yeah, I know exactly what that is. So that's my bar admission to the Supreme Court of the United States of America. I'm a member of the bar of the Supreme Court of the United States of America. So suck it, everybody. Yeah, I was humming under the sea. Yeah. Yeah. What's the penalty for presenting a fake bar card? I don't know. I haven't looked it up, but presumably if I were doing it in the course of trying to be a lawyer, I mean, it'd be unauthorized practice of law if I were trying to fake it. But I mean, it's a hard plastic card. I mean, it's plastic. So I mean, your theory is, I somehow forged this just for the hell of it. Let's give me a little bit of benefit. Jeez. It's not the alcohol, it's the cowboy hat and t-shirt. I don't know. Why shouldn't I be comfortable, man? How is it the Illinois State Supreme Court overruled the governor's emergency authority? He's still making new rules with threat of punishment. Well, to the degree the new rules would be in compliance with the Supreme Court's decision, that would be a thing he could do. Having a legitimacy question by Reddit subs is a badge of honor. If they said the RNC was illegal, they'd suggest you run for POTUS. Yeah, Blackleaf31 is my Reddit handle. I don't have any things under there right now, but yeah, that's why this incidentally why I have this photo, because I used to be on Reddit a lot, and a lot of people would say you're not a lawyer, and then I'd say, well, here's my bar, here's my one from the Supreme Court saying suck it. Yeah, so that's all good. Yeah, incidentally, I've definitely had people on Reddit question it before, so yeah. All right, so I'm gonna sign off before I get in too much trouble. If you like the stream, I hope you had a good time and all that stuff. I'm gonna lose the chat incidentally when I have to blur this out in YouTube, because I just basically doxed myself. So I'm sorry to the chat that I'm about to lose the entire chat. I'm really, really sorry, but I have to remove that stuff. So I have to make this unlisted and then go back and change it. So I'm sorry I'm going to lose everyone. I'm going to have to make this private and make some edits, but it's been nice. Have a good one. Bye.